he is co-managing partner of Hughes, Waters, and Askanase. They've been a bankruptcy specialist firm as long as I've been practicing. David Askanase is someone I encountered in the first days of my legal career. Wayne is very active in his church. He was instrumental, along with, I'm sure, his wife, who was probably even more than him involved, in raising funds to build a new church. So certainly is doing his share to make sure that things are handled. He is a very zealous advocate. He trends to the business side of the practice, but he's also been a big supporter of this program from the get-go. He is a new granddad, and I know that's a source of joy. You just have 4 more to catch up with me. But they are a lot of fun. To my immediate right is Johnie Patterson, also has been a long-standing supporter of the program. He is a double SMU grad, undergrad in finance and law school. He came, like myself, I'm originally from Dallas. He came down to Houston because this is a great city and a great place to practice law and to help make a difference. When you find Johnie on the other side, my experience is you better be ready to, quote, bring it, because he is a vigorous advocate for his position, no matter the merits. Just kidding, Johnie. A fun fact for Johnie, I did look on Facebook and I didn't see anything, sorry.
Not on social.
But he is the beneficiary of an apology letter from another esteemed member of the bar and others, pursuant to a court order in 2006. And I wondered, is that letter framed in your office?
No, it's not. Although it's one of the only apologies I've ever received.
Anyway, thank you all for being here.
Thanks, everybody. This is, I think, Johnie and I's 3rd time to do this presentation together, so hopefully this time we'll actually get it right. We've organized the materials in a PowerPoint fashion. You'll see them up there, and they're also in your materials, much like a primer, if you will, or Cliff Notes, so that you can refer to them as easily as possible. They are not be all to end all. We tried to be as comprehensive as we could within the bounds of a 30-minute presentation. So we're going to get right into it. Please ask questions as we're going through. There's no way in 30 minutes that we're going to get through all of the pages in here, but we're going to do our best to hit the high points. Bankruptcy discharges are the goal, especially when you're on you're volunteering on a pro bono case. You really want your client to get that discharge. That is the ultimate goal. And as the judges and Diane said previously, make it easy to get the discharge. List all of your assets. Do the exemptions properly. Don't leave your client open to a challenge by a Chapter 7 trustee or a creditor. Johnie represents mainly debtors. I represent mainly Chapter 7 trustees and creditors as well. So we've come at this from somewhat opposite viewpoints, but the goal is for your client to get a discharge. And to do that, you have to be accurate and honest, and you have to be very open with your client and tell them consequences of them not telling you everything. That they could be denied their discharge, and sometimes it could even bleed over into Title 18 and criminal liability. That's something you definitely don't want, especially when you're working on a pro bono case. Bankruptcy discharge eliminates a liability for a debt. It doesn't eliminate the debt itself, which is somewhat kind of wrap your head around that. The debt still exists, but the creditor's ability to go after your client for it after he or she receives their discharge is eliminated. So that's a distinction you need to remember. And so separate those two in your mind, because it will become important if you have a recalcitrant creditor who comes after your client at the end. They say, no, wait a minute. And he says, well, no, the debt's still there, but the liability is not. And those are two distinct legal concepts that you need to be aware of, especially if you have to come back to court and ask one of these judges for help and getting that recalcitrant creditor off your client's back. Discharge debts can be voluntarily repaid, and you're going, when in the world would that ever come up in my practice? Many years ago, I had a nice couple come to me who received a discharge 2 years prior. They were Eastern European, I think maybe Polish, but I don't remember, it doesn't matter. They had just won $4 million in the lottery. When does that ever happen? Never. Except it did to these people, and their dilemma was, what should we do? Do we have to go back and tell the trustee? Do we have to go back and tell the bankruptcy court? No, they didn't. They received their discharge, they were honest debtors, they were entitled to the discharge. But they were very conscientious, and they said, are we gonna get in trouble if we don't pay our debts? No, they're not. But that's a 1 in a gazillion situation. But if something happens and your client says, can I repay those debts if I want to? Absolutely. But they're not required to. Violations of the discharge order, which is what you want at the end, can be punished by contempt by the bankruptcy court. If that happens, if your client gets a demand letter, if they get a small claim suit or something, and if they've already gotten their honest discharge, you want to try to resolve that with the creditors' counsel informally if you can. Call them and say, I'm sure you didn't know about this. I'm going to send you over the discharge order, which you'll have a copy of in your client's file. Would you please dismiss that case? Would you please tell the collection agency to block any further calls to my client? Usually, that suffices. Always, no. That's when you go to the court with a motion for contempt. Maybe filing an adversary proceeding goes beyond the scope of your duties as a volunteer lawyer, but things may happen where that's required. Johnie, I'll pass to you.
All right. Like Wayne says, and I apologize, I prefer to stand than sit, and so it's nothing significant in it all. But the discharge, like Wayne said, is the goal. That's what you want for your client. That's the whole purpose of the bankruptcy. Without the discharge, you really are not doing much for your client, if anything. There may be a few things, but for the people that are going to come see y'all, the discharge is what you want. And everything you're going to hear today is going to help you get that discharge for your client. And, you know, the schedules are important and listing your exemptions. And you're going to hear, so I think what Pat has put together for y'all today is a very good foundation to get a fairly simple debtor a discharge, which is the goal. But you got to understand what the discharge is so you can talk to your client about it and tell them what the bankruptcy is going to do for them. And Wayne mentioned it, but the discharge is personal to your client. All right, it's a personal thing that the court gives them. Your client is no longer personally liable for those debts that are discharged in their bankruptcy case. Right, that's the extent of it. You got to understand, liens are generally not affected. And I say generally because it starts to get complicated, but in sevens and other cases, in these general cases, liens are going to pass through, the phrase is liens pass through bankruptcy unaffected. How does that work? All right. The good example is a house or a car. The car is the simplest. Your client comes in, he has an old Ford truck, and he's got $5,000 Ford motor credit lien on his truck. He files a Chapter 7. You file a 7 for him. He gets his discharge, and he says, okay, I don't have to pay my truck note anymore, right? And I get to keep my truck. Well, the answer is yes and no, right? He's no longer personally liable for that debt. That discharge order says that. Ford Motor Credit cannot make you pay this debt. They can't send you a bill. They can't call you. They can't sue you. They can't do any of those things in order to coerce you to pay that bill. However, they still have a lien on your truck. So you can say, Ford Motor Credit, I don't have to pay you. Please don't ever contact me again. Ford may then send a tow truck out to pick up and enforce their lien. All right? So, and many times this is what you want to happen. You're surrendering a vehicle that they cannot afford. They've gotten in, they bought three new cars or 2 new cars, and they can't survive anymore. And this is a Chapter 7 is the time to say, Ford Motor Credit, come take your stuff. I don't want to owe you any more money, but take your stuff. So be careful. Same for home mortgages in a 7 and even in a 13 on discharge. While the mortgage itself, the liability is gone, the lien on the house is still going to be there. So if they want to keep their house, which goes back to what Wayne just said, debts may voluntarily be repaid even if they're discharged. This is the time. I want to pay my mortgage because I want to keep my house, right? Or I want to make my car note to keep my car. You can voluntarily pay that even though the debt's discharged. And if you want to keep that, you're going to have to, all right? And so, because that lien is still there and enforceable. Only people can get discharges in a 7, all right? If you're not a person, it shouldn't come up for you guys, but their corporation is not going to get a Chapter 7 discharge. Corporations can get discharges in other chapters in 11, but they can't get a Chapter 7 discharge. Only people. All right, Wayne?
I got a question.
Yes, I'm sorry.
Yeah, on these home mortgage discharges and the voluntary payment, there's a form or there's something that the debtor can, I understand.
A reaffirmation.
A reaffirmation.
That's right.
What's the pros and cons of that from that debtor's?
From the debtor's perspective?
And what's the ramifications for the owner of the deed of trust? For
All right.
example?
This is important, all right? It's a little bit complicated, but it's important for you guys, especially if someone has their only asset is their home.
And they're trying to
Right.
decide what to do.
You're trying to decide what to do, right? And I'm gonna give you my opinion, and he's gonna give you, because we're a little bit different, all right?
That's what I wanted.
We're a little bit different.
But I'll interject one thing, Johnny, and that is if you're talking about what Judge Isger said, you've got your really, really destitute client that doesn't even have a home, but he does have that truck that has a lien on it. That reaffirmation agreement will become very, very important.
Right.
Well, John, sorry about interrupting.
No, so I represent mostly debtors. I'm gonna do mostly what you guys are gonna do, all right? I think the discharge is so important, all right, that you're gonna have to work to convince me to have my client sit down and sign and re-up on a debt that they just got discharged. Because what that reaffirmation does is it says, I am agreeing in writing that my discharge does not apply to this debt. So what have you just done? You've narrowed your client's discharge, right? The most important thing you get in a bankruptcy case. You've agreed to say it's something less than the code provides for me, right? So I am, in my opinion, I will not sign a reaffirmation agreement for my client. I won't do it. If they want to do it, they can fill it out. I'm not going to tell them they can't do it. It's their case, but I'm going to explain it to them. And we're going to file it, and the court will set a hearing, and I'm going to let the judge decide if this is the right thing to do or not. But I'm not going to participate in this. And I'll add one more thing. Ford Motor Credit, as a creditor, has a national policy. And their policy is if you don't reaffirm our note, our debt, we're going to enforce these non-financial defaults in your car note, and we're going to come pick up your car. Whether you pay us or not, we're going to come pick it up because unless you reaffirm our debt. That's their national policy. And so that creates an additional issue. Do you want to fight that? Is that enforceable? Is that an ipso facto problem in a bankruptcy case? Sometimes it's not worth the fight if your client says, I have to have my truck to get to work in the morning and all my tools are in there, and if they come pick it up, I'm done. All right? Now you're at a very practical point, right? It's probably not worth the fight. Sign the reaff, I'll file it for you, let the court have a hearing, and I'll go down with you, and the court makes that finding of no undue hardship in approving that, right? But my opinion is I will not participate in narrowing it, but there are circumstances when it just has to happen, and I get that, it has to happen, but keep in mind the discharge is everything in your client's bankruptcy. That's That's it, and you should be very suspect in agreeing to narrow it. I'm sorry it took so much time, but
No,
It's really
I'm glad you
important.
asked the question, because it's very important, because not only is it in writing, as Johnny said, this is blessed by the